Hi, Leo Dreger here. Today I want to talk to you about searching and seizing. Let's do an overview because this is a very complex subject regarding a lot of legal terms. So let's take a closer look. First thing, everyone should be familiar with the Fourth Amendment. The United States Constitution protects us against illegal searches and seizures. The law has been around for quite some time. All right, so I highly recommend that everybody read that law so that you understand what it's about. In 2000-2001 timeframe, the Patriot Act came out, which was realistically due to the terrorism and being able to expedite things. And that's very controversial in the scope of the Fourth Amendment. So I also recommend that you specifically read that law. Okay. Some of the other more generic things outside of the scope of those laws, let's look at the scope of like a warrant, for example. Okay, you have to define what's in scope and what's out of scope. They can be as generic as, let's search a whole building or a whole business, or very, very specific to a particular device. Okay, a couple other legal terms here. You have implied exigent circumstances. Exigent is a fancy legal term which means urgent. So the implied urgency of a circumstance, that can play into things, versus if it is an urgent circumstance. Okay. Other things that factor into warrants, such as plain view. If something is in plain view, then, for example, hey, if you're doing something in plain sight and obviously it's against the law, well, somebody can come up to you and say, hey, you're obviously doing something you're not supposed to be doing. Okay. Lawful arrest speaks to that arrests have to be done in a legal and lawful manner within themselves. Inventory searches. Let's say that you get a DWI, for example, and you get arrested and your car gets impounded. Well, part of the process, it would be just like they go through your wallet and your car keys and take an inventory of what you do. If there's something else that's illegal in your car, they don't need a search warrant for that. So if you get arrested on charge A, and during the inventory of your booking, well, they could also do a little undercover discovery and find something else that you didn't want intended. So we're going to talk a little bit about inventory searches. Also, searches happen at the border. Okay, so a lot of people say, I'm an American citizen. I just want to come into my home country. Well, technically, you're outside of the country. In order to get in the country, you have to basically, if they ask you, hey, I want to see what's on your laptop or things like that, then, you're opening up yourself for a can of worms. So we're going to talk about all of that in terms of legal jargon. Also, workplace searches. This has also been another controversial term over the years. Let's say that an employee has a locker at work. Well, is that locker, is the employee entitled to privacy within that locker? Or is the employer informing the employee that, hey, you have no expectation of privacy while you're in my workplace? And the same thing goes with our desktop computers for that matter. Okay, that's why we have things like log-on banners. So we're going to talk about these items. Okay, next you have the electronic surveillance communication networks. There's a whole bunch of statutes and laws and codes that you're going to want to be familiar with in the legal sense. First is 18 U.S. Code 2510 through 2522. This is basically your wiretapping statute. Okay, we're just going to do a high-level run through these, and we're going to take a closer look at each one of them a little bit later on. So bear with me. We're just going to run through them. You have 2518. This is the interception pursuant. You have 2511, Clause 2, C and D, which is consent. 2511, 2, A and I. This is for the provider. You have 2511, 2 and I, computer trespasser. You have 2511, 5A. This is the extension and telephone. You have 2511, 3B and IV, or in Roman numerals, that would be 4. Inadvertently obtained evidence. You have 2511, 2, G and I, the accessibility to the public. You have 3121 through 3127. This is the basically tapping and tracing statutes. So these are all something that we're going to want to take a closer look at. Okay. Otherwise, you have the Privacy Act, the Electronic Communications Privacy Act. There's a couple other statutory components here. You have 2701, 2712. This is statutory privacy rights. You have 2510. This is electronic communication service. You have 2511. This is remote computing in the definition and defined of remote computing. You also have the Cable Act 47 U.S. Code 551, which is for anything that you voluntarily disclose. Okay, so lots of numbers, lots of names here, but if you're pursuing a career in forensics, these are all of the statutes that and rules that you're likely to be citing frequently. So that's why we want to make sure that we know these inside and out. Also, in terms of warrants, you have multiple warrants. You have no-knock warrants, sneak and peek warrants, which has been defined, and Rule 41, which is very often overlooked, which is the actual return of property to the accused. All right, and then we'll follow up here with an applicability to hearsay, things like general records, or we'll also talk generically about what the hearsay rule is, or the business exemption record to the hearsay rule, or the applicability to hearsay such as stored records. So as you can see, searching and seizing computers or electronic equipment in terms of the legal aspect of it gets very, very complex very, very quick. I'm not a lawyer, and nor will I be advocating any sort of law, so you have to do your own due diligence here. All I can do is basically point out the details and highlight them just as I encourage you to do, but I will serve as your guide throughout that process. Okay, so we'll get into the specific with searching and seizing computers coming up here shortly.